And what's great about this evening is we've got the view of slightly differing perspectives, but on the same material. And we've got John Mullins, SC, who's going to talk to us first about the perspective from the advocate, from a senior counsel's perspective, and what he looks for in an expert witness, what he hopes for in an expert witness, and what he actually gets in an expert witness. Those three things are not always the same, I can assure you. And then we've got, and that conversation will last about half an hour or so. And then we've got Dr. Herman Edeling, who's a well-known expert, a very highly respected expert, and he might be a very capable expert, who will talk to us on similar topics to what John will talk about, but he will come in from the perspective of the expert witness himself or herself, and he will then give us the point of view from the expert, and I'm particularly interested in that. That's always informative. Just one or 2 points before we get underway. You do have a chat function with you as a viewer, and if you'd like to send through questions, please send through those questions on your chat function. We will try to accommodate those questions. We will also on Sunday evening have a follow-up webinar in which we will deal with any questions that we don't get to now, so please feel free to ask those questions. All right, without any further introduction, let's get to the topic. John, Herman, welcome to both of you.
Thank you.
John, let's start with let's start a little bit with an introduction as to who you are and what your background is very briefly. We know that you're a senior counsel. How many years experience do you have, and in what sort of area do you practice?
Yeah, and I think I've forgotten most of it, but I was an attorney. From 81 to 90 was an attorney. From 1990 I joined the bar. I think I became a senior counsel in 2002 or something like that. But the main thing is I've done insurance work throughout my career. And insurance work involves experts. So I've been privileged to deal with experts in various fields, medical, engineering, architecture, etc., from the start of my career. Been dealing with experts throughout, and it's if I were to say what the highlights are of doing what I do, one of the biggest highlights is dealing with experts like Herman, for example, and being able to learn from others and watch others and get involved in all these other fields. So that's me.
No, I agree with you, John. It's a particularly fascinating exercise to interact with experienced professionals from different professions and get to understand something of what they're saying, something from their perspective. And I must say I agree with you. I find that working with experts is particularly rewarding exercise, and particularly working with good experts. All right, let's start off with then the actual topic this evening. So what makes a good expert? And I think the first point that we should touch on is when we talk about an expert, what do we mean by an expert? And in particular, somebody may be an expert in one particular field, but not in another. And so the first point, I suppose, is that person qualified to talk within that particular field? John, your comments on that?
Ian, I made some points when you and I first discussed this about experts. Can I raise all those points as
Absolutely.
answer to your question?
Absolutely.
All right. So the first thing is our law of evidence does not allow anybody to express an opinion in their evidence. So our law of evidence says that you can't say, I think the following. You must just say what you saw or what you heard. But there is an exception, and that exception is where the field is something that the judge won't understand. Where the field is something that the judge won't understand, there you can allow expert evidence, which is what we call opinion evidence. So that's where the expert comes in, and it follows from that the expert must be knowledgeable in the field. And Ian, I don't know if I can quickly go on, but
no,
I
continue.
mentioned 10 points that I thought, after you'd approached me, Ian, that I thought are important for what makes a good expert. And I said the first is that you've got to be practicing in the relevant field. And that means when it comes to an occupational therapist, don't express a view on anything other than what's in the occupational therapy field. It means that in medical malpractice cases, if we're talking about the possible negligence of a general practitioner, I need a GP. I might well need a physician as well to speak about the consequences, but I don't want a physician, a specialist physician, to be talking about what a GP should do. The next thing is you must be as well qualified in that field as possible. And I think there are two things there. The one is experience, and the other is expertise. Experience is critical. I think as a general statement, nobody would call an expert who would have to admit, well, I've no experience in this actually, but these are my thoughts. The second is, from my point of view, as I mentioned to you, I like an expert whose CV is longer than his report, but that's not essential. Most certainly not essential, and often doesn't happen. It's just nice to have. Objectivity is critical. I need my expert to be objective. There is a place for hired guns in the heart of lawyers. There's no doubt about that. There are times when I will use somebody who I know is a hired gun, because there are hired guns in every field. But that's when I need a hired gun for short-term purposes. But in real terms, and as a general statement, for me to get an expert who isn't objective isn't ever going to help. I need an expert who can be my advisor. There's a book by an engineer, an English engineer called Mark Cater. It's a book about expert witnesses, written a while back. And Mark Cater sits as an arbitrator and he testifies, and he dedicated his book to all other members of the Twisted Arm Club, which is the way we lawyers are. And one of the points he made is nobody's completely objective. And he said, part of your job as an expert witness is actually to be an advisor. And if you're not objective, you can't advise me properly. Bottom line, in my experience, is if you're subjective, if you're a hired gun, that will come out eventually. When you testify, it'll come out, and my case will be destroyed in any event. So I need objectivity from start to finish. I've said I need somebody with the glint of battle in their eyes, because litigation is legalized warfare. That's what it is. It can be very confrontational, and you can get an expert who is the best qualified, who's got all the experience, everything is great, except that they're not confrontational people. They're people who shy away from confrontation. And I can't have that, because law, litigation, I'm afraid, is about confrontation, and not the best win. It's about the correct result. But to do that, I need my expert to have that glint of battle and say, I'm right and you're wrong, and I'm going to push ahead with it. In line with what I said about objectivity, I need to know that an expert, or I need the expert to know that you're not wedded to your initial view. If you say A, and then the facts change, to change it to B, or even if you say A, and then you realize you were wrong, tell me. I'd prefer it if you tell me before the other side, because then I can at least adjust my course. And it ties in with what I said about the advisor. I need the expert to be an advisor who will say, I'm contacting you because I have to tell you, in light of these changed facts, I no longer believe what I said, or I've seen the report of the opposing expert and I must tell you, I overlooked something. I think she is correct. So that's important. I need you to be available. It doesn't help to have a great expert who gives you a great report and then isn't available to consult with you, isn't available for a meeting with the opposition, and isn't available for the trial. And then when my expert testifies to be a good expert, I think the key is, and it's in line with that objectivity, to say to yourself, I'm not here for John, I'm not here for Ian, I'm here for the judge. I'm here to assist the judge to explain things so that the judge will arrive at the correct conclusion. If that's your approach, and we are correct, we ought to win. But please bear me in mind. If in doubt, go with my side, please. Don't let me down. And then when you testify, there's the judge in front of you, there's me, and there's my opponent, my useless, unpleasant, malevolent opponent. And I always say the key is, whoever's asking the question, the judge, my opponent, or me, approach it in exactly the same way. What's the question? What's the honest answer to the question? And if you don't understand the question, a good expert will ask for an explanation and won't answer until you appreciate the question. Because we lawyers, especially because we're in your field, we can often put the question in a way that we understand, but that you don't, because you're the expert and we're not. We're just lay people. And then when you testify, take your time. If you're asked a question and you need time to think, and just coincidentally, I recently, Herman was my expert in an arbitration, trial turned arbitration. And I saw him doing that time and again. Ask the question, looking, you could see I'm absorbing the question. I'm asking myself, what am I really being asked? And then giving the answer to the judge. And then finally, cross-examination can be unpleasant. Some of us are unpleasant when we cross-examine. Sometimes we're deliberately unpleasant when we cross-examine because we want you to lose your temper. And I think the key is, firstly, never to lose your temper. And secondly, to know that I'm your lawyer. If I don't object, deal with the question. It could be I'm not objecting because it's not objectionable. Or it could be I'm not objecting because it is objectionable, but I know you'll do very well in your answer. And so please never lose your temper, and please don't object to the question. Leave that to me to object. Sorry, Ian, I went on, but those are the points I wanted to make.
No, John, I think that was an excellent summary, and thank you very much for those points. We're already getting positive comments about the way you put that across. And one of the things that I think is very helpful is that you put what can be quite legalistic concepts into understandable terms. And John, you know, it's one of the points that Herman and I are going to talk about, and I'd like to get your input on this, is what I think of as the through flow. In other words, when an expert first gets instructions from an attorney and reads those instructions, then the next step is obviously preparing an expert report, and then of course dealing with the other side and dealing with your own legal representative, or your side's legal representatives, all the way through to testifying at trial. And one of the things that I find is that the foundation of a good performance in the witness box, and really the culmination of that performance is standing up to cross-examination, starts when the expert report is prepared. And maybe you can give us some thoughts on that, John.
I mean, isn't that so? And you're right, that must be the foundation. I suspect, I mean, I've never testified as an expert. In fact, I've never testified, and I hope never to. But I suspect that as an expert, when you go to testify, it must be a nightmarish experience if you don't actually believe in what you're saying. And on the contrary, it must be a very, well, relatively positive experience if you know that you haven't just said something, you've analyzed it, you've looked through it carefully, and you've arrived at the correct defensible conclusion, and that the basis of that is your initial report. But remember that you're not wedded to it. Things can change.
Absolutely, and I think just to pick up on that point, I think it's so important that experts also need to have a flexibility of thinking. So there's nothing wrong, as you said, there's nothing wrong with an expert forming an initial view, coming to a conclusion in a report. And remember, you know, even as counsel, we often have a situation where we're hearing one side of the story, and as the story starts unfolding and we start seeing a bit more of that picture, sometimes even during the course of the trial, we get a fuller understanding of what in fact the picture is, and how strong our position is. And it's important to maintain that flexibility of thought and to communicate that across to your legal team, because we rely, as counsel, we rely to a great extent on our experts in these types of matters. And that sort of flow of communication is absolutely essential.
Isn't that a wonderful illustration, Ian, that you gave? Because I'm thinking back, when I was an attorney, I noticed how attorneys rely on advocates because they're going to do the trial. How often my advocates' optimism would wane and eventually become pessimism the closer we got to the trial, because she was going to have to do the thing. I don't want that, and I don't want that from the expert. But by the same token, we as lawyers, we also so often have to say to the client or advocate saying to the attorney, look, I was very confident because of this and this and this, but I was unaware of the following. Now that that's happened, or now that I'm aware of that, we need to reconsider. And it's the same with experts.
Very much so, John. And what I find more and more, and one of the amazing things about our profession, I'm sure experts find the same thing, is that as you go on, you keep learning and learning from day to day. But one of the things that I'm finding more and more, I think when I watch a good expert in the witness box, I sometimes think to myself, what is it that makes that expert particularly good? And one of the thoughts that comes to me is and it relates to something you've said. It's a kind of clarity of thought combined with a confidence that comes from what I like to say is you're right. Yeah, it's not just a veneer. It's sort of like a rock solid certainty in what it is that you're saying. And I think in this way maybe there's a similarity between our role as counsel and the role of the expert. I know. Generally, sometimes I'm wrong, but generally I know when I'm going to have a strong performance in court, and I know when I'm on top of my facts, I know when I'm on top of the law, and I've got a sort of deep confidence. So I might feel nervous, but beneath that nervousness is sort of a rock bed of confidence, and that then translates in my performance. And I think that it's a similar experience for experts.
Look, I couldn't have put it better, but I was thinking while you were saying that, again, to the last time I led Herman as a witness. I think, because we did win the case, I think that there were times when I was listening to Herman answering a question. And, you know, to some extent as a lawyer, you only find out what the hell's going on when your expert answers the question. But I think there were times when when the same question passed through my mind, why is it going so well? And I think I said to myself, it's because Herman knows we're right. And he knows that he can explain to the judge why we're right. Which is
very much so, John. That I think that, and I wonder, and it'd be interesting to speak to people, for instance, actors on stage and other people that do sort of live presentations, whether there isn't a similar sense, sort of deep down at the core. And it'll be interesting to hear Herman on this a bit later. But at the core of what you're saying is that certainty that, and I must say in my case, and John, I don't know what you experienced, but I don't always have that feeling. Quite often you go into court and sometimes you're in a position where your client doesn't want to settle. You have an instruction to continue with the case and you have to do your best. That's your job and you'll always do your best. But that deep down rock solid confidence isn't there. And I found that those experiences can be quite difficult. You know, the case can unravel, but also that I can feel that I'm not really as solid as on other occasions.
I'd like to say I've never had that experience, but maybe that's the test of an advocate is those cases where you're not that convinced. And if I think back, I suspect sometimes in those cases what I do is ask myself, who other than me am I going to pretend I am today?
Yeah, absolutely. I've got a question from Paul Dahlmeyer. Let's put that to you. He makes the proposition that he's somewhat disturbed that questions are sometimes asked deliberately to provoke a witness. John, you know, we earn our living in a rough neighborhood. You know, there's some tough characters out there, yeah. and they know how to get ahead, and sometimes it's not through the Queensberry rules. You know, they will go to sometimes you know, it's lengths that you might be surprised at to win that case. But certainly there's no question that there are questions that are asked of witnesses to unsettle a witness and even to antagonize that witness.
Yeah, look, let me say this, and I'm going to bring Herman into this again, and it's not, you know, coincidental that I am, but look, the judge's job is not to allow improper questioning, but by the same token, the judge's job is to not interfere too readily, so that a judge will often allow unfair, overly aggressive cross-examination simply because they don't want to interfere too readily. You don't want to afterwards say, well, I actually shouldn't have stopped you there because you were getting to a point, maybe a bit rudely, but you were getting to the point. And so, so yes, as you say, it's a rough neighborhood. It's a rough neighborhood within certain bounds. If you don't lose your temper, you'll be okay. I think back to a case where Herman wasn't my witness, he was somebody else's witness. So I was watching with interest because we shared the same interest in the case. And he was very roughly cross-examined. I mean, it was so unnecessarily aggressive before an acting judge, and acting judges are always going to be less inclined to interfere. But I at a stage stood up and said, look, this is not my witness, but this is just impermissible. Well, we still won the case. It went on appeal, and on appeal, the opponent who had been so rough in the cross-examination before 3 judges, when he stood up, he just said 3 words when the leading judge said, wait, I want to raise the following with you. In the trial, you used this language and that language, etc. And he was, you know, really attacked for it, and fortunately lost the appeal. But the point is, yes, it is a rough neighborhood, and maybe there are times when it shouldn't go so far, but there are reasons why it happens, and generally, so long as you do your job, so what if she is being overly aggressive? The correct result will occur.
You know, John, just to agree with what you're saying, and just to add this last point on this aspect, but you know, it often, I watch my opponents with a good expert, and if that expert is standing their ground and they sort of badgered and unfairly treated, to my mind, that often works to the expert's advantage, particularly, as you've said, if they can keep their cool and keep making the points that are unsettling the other side and stick to those points. And that's where maybe that glint of battle comes in, where if they've got the fortitude to just stay cool and stick to their line, it actually creates a almost winning dynamic for that expert. We've got a question from Philippa Stiles. Hi, Philippa. Nice to know that you're watching. She raises an interesting question, which maybe will then bring Herman naturally into the conversation. But she says that she finds that some attorneys don't know how to write proper instructions, and so she has a problem, and she says has to rewrite the instructions for the attorneys so that they're clear and understandable. And she then makes the further observation, which ties into a point we've made earlier, is that at trial, that becomes obvious, particularly with inexperienced experts, where she says they're talking apples and oranges between competing experts. John, I think let's get your comment on that, and then let Herman comment on that as well, and let's start with his section of the show.
I suppose it's more Herman's field. So let's see what Herman says, but just to tie into what you'd said earlier, you know, and you'll say the same thing, Ian, over all my career, I've seen an honest witness who gets attacked in cross-examination looks better because they are being honest. They can be diffident and not all that persuasive until they get attacked. And then suddenly you can see they're telling the truth because they are outraged at being attacked when they tell the truth.
Absolutely, John. All right, Herman, let's bring you in. But before we do that, we actually want to put up a poll, which before we move into Herman's section of the show, and I will actually, Herman, we can start off with that question from Philippa, but the poll should be on your screens now. And if you could please just take the time to complete that poll, it'll help us to make sure that the content of these webinars is relevant. There is a lot of potential material for us to cover, so we'd like to hear what it is that you as a viewer would like to say, and that'll help us to streamline the content that we provide for you. So we'd very much appreciate it if you take a few moments to complete that poll. All right, Herman, we've just had that, I think, that very good question from Philippa, and something that that shows where sometimes there's a disconnect between the legal profession and the experts that they're using, particularly when it's busy and there's a flow of information backwards and forwards. I suppose things can't always be perfect. But from your perspective, what are your comments on Philippa's question?
Okay, well, thank you very much. Let me first just say what an absolute pleasure it is to have a conversation with Ian and John. Thank you very much, gentlemen. And thank you very much, Philippa, for the question. Attorneys not writing proper instructions, well, I have that all the time. That 95% of attorney instructions I get says, here's Mr. or Mrs. So-and-so for a medical legal report, thank you very much. And that's all it says. Sometimes attorneys have a whole lot of stuff from a template, all sorts of rubbish that doesn't relate in any way to this case, but it's just sort of a general communication that you already know. But the actual information about this particular case is very thin. So, yes, I strongly recommend that attorneys should be mindful about writing sensible instructions. They should tell the expert, what is it that is in conflict here? What is it the dispute? What is the issue? And why do we need your opinion? What is the element that we need your opinion on? So now I'm interested, Philippa writes the instruction. I'm not sure, Philippa, does that mean that you write it and send it to the attorney, or you write it and send it to your opponent, or how? Because I just swallow, I do nothing, I just write my report the way I think it should be. But if there's, to me, any lack of clarity in something, I phone the attorney, and I often end up doing that. Phoning the attorney and saying, look, this document I need, you haven't given it to me, or here it's not clear. Are we only talking about quantum here? Have the merits been settled? What do you need my opinion on? So that is my take on the first part of Philippa's question. My take on the second part is that I really dislike meeting in expert minutes or court inexperienced experts, because they argue about stuff that they don't really know what they're arguing about, but they feel for some or other reason they're being paid to argue. And that's not really what they're being paid for. They're being paid to form an independent opinion and to analyze and come to a conclusion and then to explain that conclusion. And if that is the same as the expert on the other side, then everybody wins, because there's no reason for a fight. But it is unfortunately so that a lot of experts, especially inexperienced, seem to feel their job is to argue with the other guy. And I think that is the basis for a lot of unnecessary and wasteful argument. Thanks, Ian.
Herman, can I just on that point get your views on the experience as an expert of being instructed as you know you usually are by one party, one side, as opposed to the experience as an expert being instructed jointly by both parties. So a joint expert by the two parties.
Okay. Ian, John also touched on this, that nobody is totally objective or totally neutral. And that is so. We are all human beings. We've all got our own experience and context. But there's a very important thing that we cannot get away from, and I'd like to call that subconscious bias. And no matter how much anybody protests, it's very difficult for anybody to say that they are totally free of subconscious bias. And the basis for that is this. When John and his attorney say, Herman, will you please write a report and come and have a meeting with us and chat to me, they treat me like a friend. They don't ask me to crook, they don't ask me to lie, but they're just friendly with me. Now, first of all, the natural response of a doctor when a patient walks into your room, he needs help, so you want to help him. Now, here there's an attorney who writes you a letter or comes to see you. They want your help, so you like to help them. So your natural inclination is to help the person who's asking for help. Now, you've got to know that this person who I want to help, because I asked for help, that's my job in life, and also they're very friendly and they're very polite to me and they make me feel good because they tell me that they value my opinion, I must be dead sure that I don't favor them against the other side. Now, that's what every expert has to do. And I can tell you it's difficult. So you have to have a fight with yourself. There's a conflict internally every time to make sure that no matter how you feel, that in your scientific analytical approach, in your reasoning process, and the conclusions you draw and the opinions you express, that they do stand the scrutiny of reason and neutrality. Even though your personality is pulled to want to help the guys who are friendly and want to not help the guys who are nasty to you. And I can promise you those guys are really nasty. So it's very difficult, but we have to do it. And I think that's part of the challenge. Being an expert witness is not an easy job. It's a job where the job satisfaction comes from doing something that's difficult to an acceptable standard. That's where the satisfaction comes from. But now you asked me, Ian, what I think we should be doing, where there should be joint instruction to a single independent expert. Now, this has never happened to me, but I really would love two lawyers to write to me and say, we're in a dispute about this. We both would like you to write an explanatory report about this aspect to help us both understand our matters better. Because that would take all of the difficulty out for me. I wouldn't be pulled in any direction. I wouldn't feel there are nice guys and lousy guys. I'd feel, well, here are people who are trying to solve a problem. Let me try and help both of them to solve their problem. And I think that would be easy. Now, I do have an almost experience like that, which has been very eye-opening to me in all the mediations that I've done. Because every time I do a mediation, I am in that position. I'm not appointed by the one side or the other. So in the mediation, I realize that I need to be neutral, and it's easy to be neutral. I've got to be objective, it's easy. I'm polite with both sides, I'm professional with both sides, but I don't have that difficulty. So I am a strong promoter of the concept of finding experts who really know their job and coming to an agreement with your opponent on the joint appointment of a single expert.
I've had one or two experiences of appointing joint experts, and I've found it's much easier to deal with that expert. It's almost as if the pressure is off them, and they can. It's sort of easier for them to fulfill an objective, a properly objective role. John, I don't know if you've had experience, or if you've got any thoughts about joint experts.
You know, I'm probably wrong in what I'm going to say. I generally represent the plaintiff these days. It's just something that happens in your career. And I'm wary of joint experts because in one way or another, that joint expert becomes the judge. When I say one way or another, if the joint expert says something you don't like, well, to start with, you might say, she's right, I'm wrong, I don't like it, but that's okay. But if you don't like it, you're now handicapped. You're having to differ from the joint expert. So I'm very wary about it, but the objective part of my head, and being a lawyer, there are not many objective parts of my head, but the objective part of my head says it's the way to go. And I have seen that when you choose an expert in which both parties have enough confidence, and you're careful to instruct the expert on the basis that this is not coming from one or the other, it's from both of us because we trust you to tell us. I have to admit, so far it has worked. I'm just wary of it, but it has worked, and I think it's the way to go.
Ian, can I just fall in there for one moment?
Sure.
Just to clarify something about what I mean by a joint expert. I definitely don't mean a judge or a decider. In other words, I don't believe that any party is tied to the opinion of a joint expert. I believe that the joint expert's job is to investigate the facts and explain them in lay language so both parties can understand. On the basis of the explanation, the parties can still argue and they can still litigate or mediate. And the other point is that, so as a joint expert, I wouldn't say he was negligent or he wasn't negligent. That the parties can work out, the lawyers can work that out. I will explain what happened. I will explain what I think should have happened under the circumstances, etc. And then the other thing that I think is very important is if there is any agreement to appoint a joint expert, that agreement is not cast in stone. So if any party gets the report of the joint expert and finds that the expert is favoring the other side, at any stage, they should be free to say, all right, I'm withdrawing my support for this expert. I'm going to appoint my own other expert. And I think in that way, it remains fair.
And Herman, if I could add this, you know, I really do understand what John is saying, because from a litigation perspective, it's a bit at odds with what we're doing. You know, it's an adversarial process, and you're now bringing in a sort of an independent, you know, in a sense, an arbiter. So it doesn't fit comfortably within that mold. Where I think it is more appropriately dealt with is in a parallel way of resolving disputes. So for instance, I have in mind mediation, where we might find that process lends itself more properly to the appointment of joint experts, and we can use joint experts in a more productive way. So for instance, those reports could be confidential, and then you don't have that sort of one up on the other side. John, I don't know what your thoughts on that point are.
As I say, I think joint experts is probably the way to go, and I can see we'll be using it more and more, especially in quantum. I think it is the way to go. But you know, it just reminds me, one of the worst situations you can be as a lawyer is if you, and it'll usually happen to a plaintiff, not a defendant, because a defendant generally can't point an expert without the plaintiff knowing. It's technical, but is whereas a plaintiff, you approached an expert, you got an opinion you didn't like, you decided to bury that expert, which you can do in our system, and went to another expert, and then your opponent goes to expert number one. And expert number one says, sorry, I can't help you because I've given an opinion already. They say, oh, that's interesting. Who to? And they say the plaintiff. And if your first question to an expert is, you were previously asked for an opinion by the plaintiff and you gave it, but they chose not to call you, I mean, you've got all the credibility in the world. So I see it the same way when you're a joint expert and I decided not to accept what you say. I'm on the back foot.
Okay.
But it is the way to go.
Yeah.
Good.
And we asked, I mean, I must say, I'm starting to see it, particularly as you say in the quantum aspect, where you know, it's many of those reports. It seems to be the trend now that we're sort of paring down the number of experts, and on the less controversial aspects, I suppose, are much easier to manage and make sense. It does seem to be working its way into the way we litigate as well. Just a last point from Philippa on this is that she actually says that her experience of being appointed as a joint expert has been very negative. And she makes a point, Herman, and maybe you can comment on this, and you know, what your thoughts would be. But she says that if her report supports one side versus the other, the aggrieved attorney refuses to pay the bill, which seems to me quite a churlish response. And I would have thought that the ultimate sanction, you know. But I would have thought.
So let me say that I have a lot of empathy for Philippa's issue, and I'm sure she's right. But what is apparent to me from other comments Philippa has also made now is that there are fundamental differences between a psychological expert and a medical expert. Because what medical experts do is the same as clinical diagnosis. They diagnose a physical injury or a physical disease or physical condition, and they deal with something grounded in physical medical science. The whole approach of a psychologist is different. It's a different condition, it's a different science. And what I say as a medical specialist might apply to medical specialists and might not apply to psychologists for reasons that Philippa could explain better than me. So I'm fully willing to accept that what is good for the goose is not good for the gander.
But can I just jump in there and say it is, and I'm sure Ian will agree, it's highly unprofessional and improper for an attorney who agreed that you should be a joint expert and who isn't then happy with your report to think that she or he can now refuse to pay you. I mean, that is something that could and should be reported to the Legal Practice Council. It's just unacceptable.
No, I absolutely agree. And, you know, John, it goes to, you know, as I was reading that out, the thought occurred to me, it goes to the point that you made earlier. And that is that what you're looking for is an advisor. And in fact, if the expert has the integrity and the professionalism to make a finding, and the attorney is not happy with it, presumably at a fairly early stage in the case, certainly before trial, I would have thought that attorney should have their respect for the expert and appreciation for the expert increased. Certainly, I think that would be my response as well. We've got, you know, at least I know now what's going on. And what Herman's point is right. Maybe we don't agree with it, and we're actually going to go and find somebody else and double check it. That might be quite the right thing to do. But to adopt that sort of churlish approach, I completely agree, John. That's bordering on unprofessional conduct, if not very squarely within that realm. All right, Paul. I've got one or two comments that have come through that I'd like to just pick up from the questions. Paul Delmeyer comments, Herman, he says, well said, and he agrees that the knee-jerk response of clinicians is to help, and it's part of our training. And he has a concern that experts don't always do that. So you know, essentially what he's picking up on, and it's interesting from my point of view, is it seems to me that quite a strong motive from a healthcare professional to try to help the person that's come to them. I must say I didn't quite appreciate maybe how strong that imperative is.
Ian, can I just possibly help you to interpret Paul's acronyms? Paul refers to EBM, and I think Paul is referring to evidence-based medicine.
Right, yeah.
Paul expresses the concern, does evidence-based medicine potentially fall through the cracks? Now, I'd be interested to hear other people's comments, but I just wish to state that in clinical medicine, we believe very strongly in evidence-based medicine. And in my view, in medical legal practice and expert evidence, we should believe equally strongly in evidence-based medical legal opinion. When experts try to go away from evidence and try to form opinions in a vacuum, that is where danger lurks. So I believe very strongly that we should base all our opinions on evidence. And another way of referring to evidence is facts. We must always be mindful of all the facts. And if the facts are such that there are potentially contradictory facts that cannot coexist, we have to be flexible enough to say, if these facts are true, then this is my conclusion. But if those facts are true, then that is my conclusion. We can't just wish away the facts that don't suit our prejudice or don't suit the guy who's paying our bill. We have to be very firmly footed in evidence-based medicine.
And if I can jump in, sorry, if I can just, and we lawyers must always remember it's not just the opinion, we need to prove those facts, isn't that so?
Yes.
Yeah, sorry.
Very, very much so. And just to add to that as well, is that you mentioned earlier, I think, Herman, that it's not, the expert shouldn't make the finding of negligence. And of course, that's the legal position, is that the judges have said to us time and again that it's not for the expert to make the finding of negligence per se. It's for the expert to state the facts, and it's the role of the court to make a finding as to whether negligence has occurred or not. So I think it's important to bear that distinction in mind. The other point about it, Herman, is when we approach an expert and you know, we're looking for an opinion on something. Often it is factual, but where it becomes a little bit more of a grey area is when we're looking at the conduct of that professional within the standards of that particular profession, and whether the standards have been complied with. And I'd be interested to know how you deal with that particular situation. So how do you go about dealing with where the standards have been complied with or not? It's a little bit less of a straight factual thing.
Yeah. Well, Ian, even though it's more difficult and it's more vague, it still has to be based in facts. So the first point of departure is to investigate well and fully with all available information what actually happened, and to develop for oneself a storyline and a timeline. So when the nurse wrote that, at what time did the doctor say that? At what time did the patient's husband come and visit her and observe this thing? So one has to develop for oneself from all the sources of information, minute by minute and hour by hour, what actually happened. And it is in analyzing that one starts to understand how the pathology was unfolding, getting worse, getting better, what was being treated, what was being investigated, and how things were responding. So that it's first a detailed factual analysis. And in that sense, it's very similar to a Sherlock Holmes story. You just want to investigate what actually happened. And when one does that, one must be completely neutral and completely open-minded. Once one has come to one's own satisfactory position of thinking that you now understand enough about what happened, then one has to go and dispassionately take oneself out of one's own shoes and place oneself in the shoes of this imaginary person who's called the reasonable doctor. And then from the point of view, from the viewpoint of what you consider to be the reasonable doctor, if you had been there, reasonable doctor, and this had happened, what would you have done? And then you have to see, well, it could be this or this or this. You might find a range of things the doctor could have done, which would all have been reasonable. And then this thing that the doctor did, was that in the range? And then one must unfortunately express that opinion. So under the circumstances, I'll give you an example. Patient had a spinal operation for numbness in the right leg and a weakness of the big toe extension, for example. That was enough to prompt an operation. Post-operatively, the patient says the whole right leg is weak and half of the left leg is weak. Now, surely, when the doctor knows about that, which should be as soon as possible after the operation, the doctor should do something. There are various things the doctor can do, but the imperative will be to make an appropriate diagnosis with the correct amount of urgency and to take the necessary corrective measures if that is possible. For the doctor to say, oh no, don't worry, that's a normal consequence of this type of surgery, we'll check again tomorrow. And then when the patient tomorrow says, no, it's not only half of my left leg, it's both of my legs, and the pain is intolerable, the doctor just pushes up the morphine and says, don't worry, it's normal, it will all go away. And then 5 days later, it hasn't gone away. So then the doctor says, okay, let's do an MRI scan. Oh, goodness me, there's an extradural hematoma. Let's go back to theatre and remove it. Now, it's clear that by no stretch of the imagination can you say it was reasonable for the doctor to wait 5 days with that information. But the job of the expert is to say, under those circumstances, one can do this or this or this, and any of these would be reasonable. But I can find no justification for not doing anything or for doing that. And that is as dispassionate as I can be about it.
Herman, I think that sets it out so nicely, because it's really that range of reasonable options, and it's not as if there's one particular option, but does it fall within that realm? And I'd just like to then go to a comment from Jimmy Kiriakou. Hello, Jimmy. He says, as an academic, I find it quite interesting that when my students don't know what they're talking about, they tend to resort to jargon and technical language. Isn't that true of all of us, whether we're students or not? The best students convey their ideas clearly and simply. I would be interested in how our guests see this issue in the context of expert evidence. Well, there we go. I think that goes to that clarity of thought. John, let's get your views on that to start with.
I mean, Jimmy, that's a difficult thing, because I certainly don't want an expert who simplifies things too much and starts sounding not like an expert, you know. So yes, I think clarity of thought and clarity of explanation, and don't simplify it too much.
And I think there's a difference there, John, between clarity of thought on the one hand, and not really knowing what it is that you're wanting to say, and then obfuscating. In other words, trying to cover up with fancy language. And it's amazing how sort of easy it is to pick that up. You know, the moment they're in a corner, they start resorting to all sorts of jargon, and I think that's apparent to everybody.
Although years ago, I remember calling a geophysicist. I never understood a word he said in the evidence in chief, in the cross-examination, when he answered the judge, but the judge seemed to like what he was saying. I think all the lawyers said, we don't understand a word he's saying, but it sounds right.
I need to go and Google what a geophysicist is, but I won't ask you, John. I'll save you having to answer that. Herman, your thoughts on Jimmy's question?
Yes, I think that when, both at the time of writing a report and at the time of giving evidence, the expert must understand that he's communicating with lay people. So however complicated the concept is that he has considered or worked out, he must explain it in small words. And he must explain it using words that everybody understands, and he must explain it to lay people. So I understand Jimmy's use of the word simple in that context. Not that the explanation must be simple, but that a person must use simple words to explain a complicated concept. And I believe one can do that. I actually believe that all doctors who are really interested in the well-being and welfare of their patients develop that skill. Because a doctor's job, apart from making a diagnosis and treating, is also to explain to the patient what's going on and to get buy-in from the patient to be part of the treatment plan and to do the right things. And I think doctors can and do get a lot of experience of explaining complicated medical concepts to lay people. And they must use the same skill in writing a medical legal report, and they must use the same skill in court.
Makes sense.
No, I think that's very true. Let's just get to Anita Greef's question. She says, now with COVID-19 lockdown, from the OT's perspective, not being able to do actual clinical assessment and testing to link to medical facts, finalizing reports is and will be extremely difficult and does not meet EBM criteria. Herman, I think that one, if you can deal with that, please.
Yes, I think all of us that work in the medical legal field are a little bit at sea at the moment, because I don't think that the government considers medical legal practice to be an essential service. So none of us are really allowed to do our work. I expect that the Legal Practice Council and the attorneys associations, etc., will possibly get at some stage legal practice listed under the essential services on lockdown level 4 or maybe lockdown level 3. And my view is, as soon as that happens, it will be justifiable for medical legal practitioners to open up their practices, and because they will be providing supportive services to legal practitioners. So when the courts are open and lawyers can work, then I think medical legal experts can work. But I agree with Annika, it's very, very difficult to work from home when you haven't got access to all sorts of things. The only advice I can give is speak to the attorney or phone the doctors or use Zoom, get whatever you can by online communication or by email of documents. But the things that, I mean, there's no way an OT can do a physical functional assessment online. So there are limits that we cannot do. And I think it's just up to each one of us to think carefully about what we can do and to do what we can, which is reasonable and worthwhile, and wait for the happy day that legal services are considered essential.
No, I mean, I agree with that. The courts are starting to adapt. Like, obviously, there's a limit to which the system can tolerate what's happening at the moment with the lockdown. But I read an interesting judgment from one of the federal courts in Australia today, in terms of which the judges allowed a 6-week trial, which seemed to be quite a complicated trial. It had been running previously as well, but allowed that to to be conducted online, and went through a lot of the pros and cons on a practical level of running a trial in court. So the courts are trying to adapt. Our courts have also, John, you'll know, done their best, but of course there's a limit. When you need to do a physical examination, there's not really any way around that. And I suppose we've just got to learn to deal
Can
with
I
that.
just make a little comment there, Ian? It
Yeah.
is in South Africa now. Today I was reserved to give evidence over Zoom on Monday the 4th in a trial. Now,
Yeah,
I mean, this is
no,
something
quite
I
right.
already submitted a report, but so there are cases now going ahead online.
No, very much so. And I actually watched what was interesting, I watched a motion court live feed from I think it was PE. And I thought it worked very well. And the judge effectively did motion court via Zoom. And it went very smoothly. And it's amazing, but after a few minutes, you sort of forget that you're not sitting in court and that you're watching him on a monitor. It becomes quite a real experience. All right, as we sort of head towards the end of our time, I think let's just get some closing thoughts, John, on what you say makes a good expert in your opinion.
Well, look, it's what I said, and I suppose if you were to choose one word, it would be, I think, two words: knowledge and objectivity. That's it.
Thanks very much, John. Herman, from your side?
First of all, everything that John said. And secondly, my best tip to any expert is when you go to court, leave your ego at home.
Well, thank you very much. I think that summarizes it very neatly. And I think those 2 points, if you just took away those 2 points, I think it'll help us all in our practice. Thanks very much to John Mullins and to Herman Edeling for their time and the benefit of their wisdom and experience and knowledge. And I hope that the webinar has been informative and helps you in your particular practice. Thanks very much, everybody.
Thanks, Ian. It was a privilege. Thank you.
Thank you, Ian. I really enjoyed that. Thank you.